APS Securities and Windhorst.
Mr. West.
Good morning, my lords. I appear for the appellant, and my learned friend, Mr. MacDonald Casey, appears for the respondent. We're going to hear an application first to amend the grounds of appeal. I just wanted to check before going on to that you have all the materials that have been lodged.
We've certainly got the various notes and the application notice and the draft amended grounds. If we're meant to have more than that, we may not have it.
Indeed, my lord. What we've done is to add those to the core bundles. There is an update to the core bundle containing those materials. There's also a second volume of the authorities bundle, which contains the authorities that are relevant to the point on jurisdiction. Yeah. And I don't know if you have that or have had an opportunity.
I certainly haven't had that, and I still don't seem to have that.
We do have spare copies in court, my lord, which I can hand.
I have that. That's the one that arrived late last night.
It is indeed. Yes, my lord. Shall I hand one up?
Yes, please.
Has almost as many authorities in it as the first authorities.
It does, my lord, yes. Yes, my lord, I'm conscious there would be a slight deluge of further authorities. That's partly a feature of the speed with which things have been happening, because my learned friend and I haven't had a full opportunity to look at each other's cases and decide which ones might not be in dispute. So while there is a full bundle, I would hope we wouldn't need to refer to that many of them in argument before the Lord. So, my lord, shall I begin with the application to amend the grounds?
Yes, please.
Indeed. So, my lords, this issue was prompted by the court on the 22nd of May, when my Lord Justice Fraser invited the parties to look at the question of jurisdiction for positive conditions on suspension of sentence for contempt. And both parties have prepared those, and in order, because this is already on a fairly condensed timetable, in order to allow ourselves a bit more time, we did agree to exchange one day early. So those were exchanged on Thursday last week. Then, of course, the respondents filed a further note, which was produced yesterday and suggested further authorities. And so the reason why this is coming on quite so late is because it's been spurred on by the court's own initiative. But my lords, I just quote from what Lord Justice Mell said in one of the Deutsche Bank cases. It's the common experience of this court that new points are sometimes raised on appeal, in which case it's necessary to consider whether it's consistent with the interests of justice to allow them to be argued. That's the Deutsche Bank 2023 case, paragraph 46. It's even more common for the focus of argument to change as a case proceeds on its appellate journey, and that is not abusive. And really that's the beginning and the end of the application to amend, whether or not it's going to be in the interest of justice. Obviously, I recognise in terms of an application to amend, it comes very late before the court. I accept all the authorities that say I have a heavy burden to discharge, but obviously I do rely on the fact that the court has invited the parties to explore this area. That's what we've done. And having done so and looked at this interesting position, we've taken the view that this is a properly arguable point for our side on this appeal, and so we've sought permission to amend. Of course, I accept it comes very late, but as it's prompted by the court, that is the reason for the timing. This point, I accept completely, was not live before the judge, and it did not form part of our grounds of appeal originally. And if I just explain how the point arose before the judge, there was some late evidence in that case, but my learned friend sent me an updated draft order just after 8:30 the morning of the hearing. Paragraph 4, with which we're mainly concerned today, the fourth condition of suspension, was not part of the original application. So the application, as it was made and as it was served. Indeed, my learned friend is quite correct. It's what we're calling the fourth condition of suspension. So it's paragraph D. So
4A to C were there, but
they were indeed. It's D that was added.
And that is the subject of the application to amend the grounds of appeal.
It is indeed, my lord. Yes. It's only on that part of the order, that correspondence also dealt with some other points that were coming late to the case to do with CBIRs and whether there was going to be an automatic stay because of the Dutch insolvency proceedings. So there was quite a lot going on. The point wasn't really canvassed very much in the argument before the judge, before she gave her main judgment. There's a very slight reference to the order at the end of her judgment, and then there was a fairly short exchange before her at the end where she was presented with the draft order. I took one point about the scope of the order, but not a point on jurisdiction. And it's fair to say that all parties and the judge proceeded on the basis that the court would have jurisdiction to deal with this. So it wasn't until my Lord Justice Fraser raised this point that we then looked into it in a little more detail. It seems, having done so, that there is very little clear authority on the source of the jurisdiction to impose positive conditions. We've got Morris and the Crown.
And now you're going into the substance
Well,
of it.
I was going to say, my Lord, I don't want to overstep the mark.
No,
here.
so unless there's any more to say about whether or not you should be allowed to amend, well, I think we ought to hear Mr. MacDonald on that question.
Indeed, yes. All I was going to say apart from that was that it's clearly an important point of principle, and it does arise on this appeal. It makes a difference to my client, to Mr. Windhorst, and so I submit that we should have permission to amend.
Mr. MacDonald.
My lord, it's common ground that Mr. Windhorst bears a heavy burden and that the Denton principles apply. In my submission, having regard to those principles, the application should not be permitted. At first, the failure to comply was serious. The application raises a number of significant legal arguments, none of which were taken below or in the original appeal, and which materially alter the nature of the appeal. And those were arguments that could and should have been taken below. And the reason for that is that this has always been an application for a suspended order on conditions. So if the argument was going to be run, which it is, that in fact the court has no power to impose any positive condition of suspension. And that was an argument that has always been available. And that's apparent from my learned friend's note, which at paragraph 10 cites as its most recent case in support of the arguments he is running, the authority of Crystal Muse, which is a 2006 authority. So it was a serious failure to comply. Second, there's no good reason for the late arguments. The application notice served yesterday morning seeks to tie the late change of position to the ex tempore judgment of Mr. Justice Bryan, handed down on the 1st of May this year. But that judgment has no bearing on the new arguments made, and has no bearing at all on the principal new argument that there is no power whatsoever to impose positive conditions on suspension under CPR 81. It's not referred to in Mr. West's note in connection with that argument at all. And it only has passing relevance to the alternative argument that there is no power to impose a condition under CPR 71.8. And we do submit the reality is clear when Lord Justice Fraser asked for a note elaborating on what was common ground, the appellant went away and has tried to come up with new grounds which would radically change the nature of it.
Now, obviously in this court, we regularly say people can't run new arguments, but we also regularly say they can if allowing the new argument to be run puts the party in no worse position than they would have been if it's been run at first instance. So why would you have been in a better position if this had been run at first instance?
I think two points, my lord. One is by its mere nature prejudicial to be bounced into running an argument at the last minute. And two...
Well, you say by very nature, if you can deal with the argument, why is it by its very nature prejudicial? I mean, if the argument is right, it's prejudicial to you, but that prejudice is one that you always faced.
Well, I take your lordship's point. I think the other concern is simply the time for the hearing today, which is half a day.
Yes.
Obviously, that's sufficient for the limited existing grounds, but all the time we spend on this new point obviously detracts from that. The other point I think I'd make, my lord, is that in a sense it's already apparent that the new arguments are hopeless, because the argument that a positive condition can't be imposed is plainly wrong, because there are numerous authorities where precisely such a condition has been imposed.
Yes, I'm not sure not sure that the argument is so bad that we can decide the point on this, decide whether or not to grant permission on that basis. Supposing the court simply has no jurisdiction to impose condition D, in circumstances where you really wouldn't have been any better off if this point had been taken at first instance, why should we not then allow the point to be run?
Well, I think, as I say, my lord, the point is actually the argument is that the court has no jurisdiction to impose any of the conditions. That is the nature of the argument being run. The argument is there is no jurisdiction to impose any positive conditions under CPR 81. And it can't be different as between a positive condition to require disclosure or a positive condition to attend for examination.
I mean, obviously the draft amended grounds only go to condition D,
They do.
and that might be said to correlate with part 71.
It might, but that's not the nature of the argument. The argument is no positive conditions are permissible under Part 81. And if that argument is right, it's either right for all the conditions or none of them. So it must be the case, if that argument is right, that there's no power to impose any of the conditions for A, B, C, or D.
Now, supposing that that argument were right, wouldn't it be a good idea for the court to say something about it, rather than allow people to go on assuming that there is a power that there isn't?
Well, perhaps, my lord, I mean, I see the direction your lordship is thinking, and in the interest of time, I'm not sure it's worth taking up further argument or time on the point, but as I say, I do emphasise the argument is actually it's no conditions at all.
Yes, I follow that. Anything you want to say in reply, Mr. West?
No, my lords.
I think we'll go out for a moment.
Court rises able.
Yes, I think it's right. This new court rise, if they... Yes. So, I like that. Encouraged to go to the notes. No, so exactly. No, I think that's not fine. Let's see. Yes, I did wonder about this point. I attended the hearing over the site. Well, yeah, and that's straight from 71A. That's all the way from. I think it's right when we get to. Yeah, no, I think that's right. No, absolutely. What a mess. Maybe they should take it all to hand. Yes, exactly.
Court rises able.
Mr. West, Mr. MacDonald, we will grant permission to amend the grounds of appeal in the manner proposed. Reasons for that will be given in the judgment in due course. I would just add this with Mr. MacDonald's point about timing in mind. Although I personally have not looked through all these authorities, my impression is that an awful lot of them are just, this is what happened in that case, rather than any reasoned consideration of whether it could or could not be done. So I'm hopeful that we do indeed manage to keep more or less within the original time estimate, because the points can be boiled down.
I would hope so, my lord, and I think on ground one, which is length of sentence, I'm not expecting to be very long on that.
No.
And so I would hope we can deal with things efficiently. Can I ask, my lords, whether you have a preference as to which order we take the grounds in?
I think it's probably best to let you follow your
Very
own
good.
course.
Thought before I set off, I should check. Well, on ground one then, my lords, this is the point that is not the condition of sentence, it's the length of the sentence that was passed of 18 months that was suspended on the conditions in the order. and I mean, I don't want to repeat what I've said in writing, my lords. This is a point at which any person who's sentenced has a right of appeal without needing to seek permission. Mr. Windhorst does so, and he asks that the sentence should be at least considered by your lordships, and that you should consider substituting the 18-month sentence for a shorter sentence. I accept, again, it's another heavy burden on my side, all of the authorities which say that this is preeminently an area for the first instance judge. It is an evaluative judgment. There's been a weighing up of factors, and the judge was presented with the relevant authorities, especially the Supreme Court in Crossland, which she correctly referred to, and she did refer to the fact that the court should impose the shortest period of imprisonment commensurate with the seriousness of the contempt. So I accept I have a long way to go to convince your lordships that the exercise of her discretion was wrong. But I do say that it went too far because what the judge was doing was sentencing Mr. Windhorst simply for the failure to attend the hearing. There was a sole ground of contempt for non-attendance. That was proved to the criminal standard, and that's what Mr. Windhorst has been sentenced for. There were other orders requiring production of documents. Those were not part of the application for committal, so they do form part of the background to the case, and I accept that those are live orders, many of them with penal notices. I don't step away from that. But I think it's important from the court to start with the proposition that this is a simple failure to attend. It's a failure to attend, which I accept also is deliberate. But what Mr. Windhorst did in this case was not to completely ignore the court process altogether. What he did was to arrange for his solicitor to attend the hearing instead. So he did engage, but he didn't attend in person. And he's accepted in his evidence that was a bad decision. He's explained in his evidence the reasons why he said he chose not to attend. And the judge dealt with those and gave them, it's fair to say, quite short shrift because that evidence was very short and was served very late.
And it was also part of a pattern. I mean, it's got to be seen against the pattern of his behaviour, hasn't it?
Indeed, my lord, and that is right. I think all I would say on that point is that although there were several hearings, many of them were in fact adjourned by consent because it was thought that there was a need to spend more time looking at documents, or there was a need to deal with points about service. So it's not the case that there have been, I think it's 6 hearings which he has failed to attend and has simply not turned up. There has been some engagement to deal with that. And there is only one actual contempt of non-attendance which is being dealt with today. In contrast with some of the cases in the bundle, and I should say, I accept the authorities say it's not helpful to cite other cases, and I'm not planning to take your lordship. I might just touch on the 2 cases in my skeleton, but in contrast with some of the aggravating features in those cases, Mr. Windhorst has not been found to the criminal standard that he's lied. Indeed, he hasn't attended the examination, so he hasn't given any answers so far. There's not been any finding, as I say, about his documents, and the respondent, ADS, didn't apply for any committal order in respect of the obligation about documents. What I would say is that the sentence of 18 months seems, on this side, to be at the very high end, which is on a parity with cases where there are freezing orders and there's a fail to comply with the requirement to produce an affidavit of means or disclosure under those orders. And in those cases, there are very many aggravating factors, in particular the case of Mr. Vick, who's been in and out of the courts for well over a decade. And there have been specific findings about deliberate falsehoods that were told in the witness box and failure to produce documents and findings of contempt about that. And I think while this is a decision for the first instance judge, it obviously sets a signal for the lower courts. Part 71 is used throughout the court process. And if a sentence is upheld for a year and a half for the simple failure to attend, that's a decision which will may well be followed in other cases where the courts will say, well, you know, here is somebody. There were some aggravating factors, of course. I accept that, but I say the judge did not weigh this appropriately and lost sight of the fact that there was at bottom just a simple contempt of the failure to attend. think, my lords, that's probably all I want to say on that ground, unless I can assist you any further.
No, and we've seen your skeleton, of course.
Indeed. Shall I move on to the next
Yes,
round?
please.
Indeed. So, ground two, my lord, is in two parts. The first, and again, I accept that it's only the second part that was raised before the judge at the hearing. The first part is the issue that the fourth condition of suspension, as we've called it, the requirement to produce documents before the hearing, is a requirement that Mr. Windhorst produce documents that are in the defendant's control rather than within his control. And on that, my lords, I just say simply as a matter of principle, the order ought to be defined with reference to Mr. Windhorst's control, because control is the other part of production. If somebody is to produce something, they can only produce it if it's within their control. Obviously, that doesn't just mean personal documents. If he's a beneficial owner or director or has other means to compel production, then those documents would be within his control. But I don't think it could be right as a matter of principle for somebody to be ordered to produce documents in the control of a third party, because there may well be documents that the third party has that are not within the control of the person who's been ordered to produce them. And that's going to be all the more where, as here, the party in question, who is the judgment debtor, is insolvent, and there's been an appointment of an office holder. Now, my lords, I accept there's no evidence about the effect of the Dutch insolvency proceedings before the court, but the court should be alive to the point that there is an office holder appointed here. It's likely that at least some of the control of the company will have passed to that office holder, and that's likely to prevent at least some of the company's documents being accessible by Mr. Windhorst. Now, the respondent in reply to this has conceded that they would accept a variation of the order to say, well, insofar as this is impossible, then he need not comply. He need only do what he's able to do. But in a sense, that's the same thing that I'm saying, that it should be defined within his own control and not the control of a third party, because either it's in his control or it isn't. I accept there could be arguments on this point. It may not be entirely clear whether there's control or not, and there may be disputes about that, but I think there may well be disputes either way about the nature of control and who has control and who doesn't. And it may, sorry, I've just lost my thread, my lords. Yes, I think there is also an interest in suspended orders for committal having as restrictive conditions as possible. There's authority that says that they will be construed restrictively by the court, and that's obviously potentially a safeguard where somebody comes to court and says, well, look, this is actually impossible. But in my submission, a person in Mr. Windhorst's position shouldn't have to rely on a later construing of an order in order to avoid contempt. In my submission, the appropriate course is for the court to say that your document should be those that are within his control, and that's why I say the order is wrong. Now, as I say, I accept this wasn't a point that arose before the judge. It wasn't a point that she dealt with, or there was any argument on. But it is an important point, and I think there is a concession on the other side, and so I would hope this point is if not capable of agreement, certainly the parties are not so far apart on it as they are on some of the other points. So, my lords, unless there's anything further I can add on that point, that's all I propose to say.
Well, there had been an order of almost like effect made in a consent order by Deputy Master Elaine, which is at supplementary bundle page 95.
There have been, I accept that, my lord.
And that uses exactly the same words.
It does, my lord, and I think all I can say to that is this is a condition of suspension of sentence, and so while though it's obviously important for the court's orders to be obeyed, and it's a serious matter not to obey them, it's an even more serious matter where you're dealing with a suspended condition that may mean you end up being committed and the sentence being activated.
No, I do understand that, but it's rather different, isn't it? Where effectively your submissions are that condition as drafted, he can't comply with it, when that condition as drafted was included in earlier orders, it appears without demur.
No, granted, my lord, I do accept that it was included in earlier orders, and certainly sometimes by consent.
The office holder was appointed after the LA.
Indeed, yes. No, that's good. Yes, my lord. Forgive me for turning my back. I'm reminded that the appointment of the office holder post-dated those orders, and so that does change the landscape a little. But I do accept the point that these were orders that were not challenged earlier, and I don't shy away from that. But I still maintain the point that a person shouldn't be required to produce orders. It may be there were potential challenges to those orders, but obviously they were made by consent in some cases, and I'm not seeking to reopen those. But the point has real bite when it comes to suspension of sentence, and that's why it's a way in which we say the order is wrong. And in fairness to the judge, this wasn't a point that was dealt with by her. This was a point that was on the order and wasn't dealt with by either side at the hearing. I do accept that, but I still say that as a matter of principle, it's important that these orders are confined to their proper scope, and the respondent does recognise that in that it's willing to offer a concession on that point. Then, my lords, unless there's anything else I can assist on that point, the second ground is a slightly wider point about the scope of the disclosure itself, which simply refers to Mr. Windhorst being required to produce all documents. So there's no guide for him in that. And as you'll have seen, what I say about that is that for similar reasons, it's important for him to know exactly what it is he's required to do. And on its face, the order could mean that the committal order comes into effect on the failure to produce even just one document. Now, there may well be arguments about whether or not there's a de minimis limit which could apply, but for the same reasons, the suspended condition of sentence ought not to leave him in a position where that may happen, and he should be given an appropriate guide as to what it is he's required to do in order to avoid the prison sentence being activated. And it's relevant, my lords, that in the discussion with the judge, she did refer to the fact that had there been an appropriate list of documents that were requested, that she might have been minded to include a reference to that.
Well, she asked, I think it was when you were making submissions to her, where you said it's possible for a list on the application that wasn't done. And she says, has any list previously been served? And I think you say no.
No, indeed, there was no list served. It was simply a request for all documents, which is obviously an expansive requirement. And this will tie in with a submission I make about jurisdiction shortly. But the point here is that Mr. Windhorst, while he's not been found in contempt of any requirement to produce documents, is nevertheless, his condition is suspended on this very heavy requirement that he produce all documents.
Well, it's all documents in his control which relate to the defendant's means of paying. You wouldn't have thought there would be that many documents.
Well, I don't have any evidence on this, my lord. But I think my point is that, as a matter of principle, there needs to be some specific requirement. And I've made some points about.
Is that because he's got so many documents, he doesn't know which ones he should produce and which ones he shouldn't?
Well, I think there are so many documents, there would need to be some kind of evaluative exercise. But I think the risk is where the consequence of failing to comply would be that the sentence were activated. To err on the side of caution would mean a vast number of documents. There's no evidence before the court about how this exercise would be carried out.
And to activate the sentence, there would have to be another application to the court, wouldn't there?
There would indeed, and I accept that these issues could be raised on that application, but I say that nevertheless, where a sentence is suspended, it shouldn't be on an open-ended basis like this. And in the other cases where similar conditions have been required, there have been more specific requirements for certain documents. There is, while there wasn't a list at the hearing, there is a list that's been produced by the representatives of the respondent just at the end of the supplemental bundle, from page 282, which lists several categories of documents. These have been presented in a expressly without prejudice to the arguments on the appeal and on the basis that it's a non-exhaustive list.
This is at
Supplemental
tab
bundle,
11.
indeed, tab 11, just at the very end of the bundle, page 282. So there is a list there of documents that at least provides a guide to the categories. I accept that even these categories are going to be they'll be capable of a disagreement, but at least it does provide some limit on the scope. Whereas to require all documents linked to the ability to satisfy the judgment might lead to a disproportionate exercise.
I'm not sure who this helps, but just glancing at this, I just thought it might go rather wider than what is ordered.
Well,
I mean, for example, 8, all documents and evidence, board minutes, written resolutions, and so on. Well, such documents might or might not have any bearing on means of pay.
Well, I think, my lord, the conditions would go together. So these would be the categories of documents, provided they also responded to the condition that they went to the utility. I agree that there wouldn't be any sense spending time producing documents that plainly didn't have any relevance to that. So my lords, unless you have any questions, that's all I wish to say on that second part of ground 2. Then moving on to ground 3, for which you granted permission. This will take slightly more unbundling, my lords. As a result of our review of the authorities in this area, as you rightly pointed out, my lord, many of the authorities do, I accept, impose conditions, sometimes positive conditions, which my learned friend has located on a suspended sentence, but there isn't a discussion in those authorities of the jurisdiction to do that. And much as was our experience in the court below, there is an assumption that the court is going to have jurisdiction to deal with this matter flexibly. But looking at the cases here, we have Lord Denning in Morris and the Crown, which explains where he says this principle comes from, and I will take you to that, my lords. But following that, there is very little in the nature of discussion on this particular jurisdiction, which my Lord Justice Fraser asked us to look at. I accept, my learned friend has done some careful research on this, and I accept there are instances where courts have imposed a positive obligation as a condition of sentence. So I don't maintain my position that this can never happen. And I think the position is slightly more nuanced than that there has to be a clear principle for a positive condition to apply. And my submission to the court will be that condition will need to be that the suspended condition is related to a finding of contempt that's already been made. So, for example, in the Wright and Rogers case, there's a finding of committal. There's a finding of contempt for failing to comply with the positive requirement to clear the driveway, and the sentence is suspended on condition that the driveway is then cleared. So that is a positive condition, but it relates to an earlier positive order which the court has found to the criminal standard to have been broken. Whereas in this case before us today, Mr. Windhorst has been found to the criminal standard not to have attended, but there's been no finding of any kind about his production of documents, and yet that's held over him as a positive condition. And that's where I say there is not jurisdiction to do that.
Is there a dispute about whether he produced any documents in compliance with paragraph 3 of the Allain order?
If I just turn my back,
My understanding is that paragraph was never complied with. the argument isn't the adequacy of documents that were produced. The point about non-production is documents have either been produced or they haven't. Or am I missing something?
Indeed, my lord. There's not. The documents point wasn't the subject of the application for contempt.
I understand that, and I do have that point, but my point was you said it hasn't been proved to the criminal standard that he hadn't produced any documents, whereas my understanding was it was agreed he hadn't produced any documents. That's why that condition repeats an order that was made against him sometime earlier. But I might have misunderstood.
Yes, I think there may have been some documents produced. I'm afraid I don't have evidence of that before the court. It was my understanding was that the judge simply found contempt on the non-attendance, as I put it to the judge there. The respondent nailed its colours to the mast and decided to go simply for that. And obviously that's an easy contempt to prove because it is completely binary and obvious, whereas the question of documents might go wider. Number 8.
First sentence of paragraph 8, I think, Mr. MacDonald being sotto voce, but perhaps
Indeed.
Fraser would be better than he expected. Deliberate strategy on his part to do everything in his power to avoid having to provide the information and documents requested.
No, I accept that is part of what the judge has said there. My point is that there's not a finding of contempt in relation to that.
I understand.
It could be we would be speculating as to whether the judge would have made a finding of contempt on that point had it been raised, but it wasn't something that was applied for.
I understand.
And so I think, my lord, that's where the distinction comes in. Now, the judge here, I think it's not completely clear from her judgment whether she was exercising a power under Part 81 or Part 71, but I think my learned friend accepts in his skeleton that if she was exercising a Part 81 power, that's accepted in his skeleton argument, paragraph 67. So the question is whether the court has jurisdiction to make an order under Part 81 of the kind that the judge made. And I think it would be helpful at this point, well, to look at the Morris decision. So this is the second authorities bundle at the beginning. So we've continued the page numbering. So it should show up as tab 16.
Yes.
It's a typewritten judgment, but hopefully it is reasonably legible. And the judge here was dealing with disruption to the court by protesters who had interrupted a trial in the Royal Courts of Justice, and some of them were sentenced on condition that they should apologise, and some refused to do so. But there was a submission made about the effect of the 1967 Criminal Justice Act, which dealt with the power of suspension for criminal offences. And Lord Dunning, at page 361 of the bundle, that's page 7 of the report, starting just before D, explains what he says the nature of the power is. And perhaps, my lords, if I invite you to read that, starting from actually the part just the sentence beginning before C. I hold therefore that a judge of the High Court still has power until just after F.
We'll do that. Yes.
Yes, so this seems to be where the common law power is best described in the authorities. It was for a time set out in the rules of the Supreme Court and then in Part 81 as a rule, but the authorities say in Lee and Walker, I won't take you to it, but there Lord Justice Cummings Bruce rejected the submission that was altering the common law and said that actually what was then RSC Order 52 Rule 7, he said that it did not confer any new jurisdiction on the High Court, and the content of the rule was just procedural, and was the exercise of a power which has never been doubted. So there's no change to the substantive law by that rule or by what became Part 81, Rule 81.29, which is now no longer in the CPR after the revisions to Part 81. So that little backwater doesn't really take us any.
You can't change the law just by making a rule anyway, could you? It'd have to be an act.
No, indeed, it would need to have statutory force, indeed. But that provision is cited in several of the cases, including in Crystal Muse and Meterick, where it is referred to as being the authority for the court to impose conditions, and the rule was in fairly wide terms. The court making the committal order may also order that its execution will be suspended for such period or on such terms or conditions as it may specify. So that's extremely wide. I don't know where the wording of the rule derived from, but the authorities are clear that it's not changing the underlying jurisdiction. So one has to go back to the cases to see where exactly this common law power derives from. What Lord Denning says is that it's the power almost to bind over, to be of good behaviour, to keep the peace, bind over and come up for judgment if called upon, and it gives the power to in effect produce a suspended sentence by doing so. But it's not a suspended sentence in the sense that it would be for a criminal offence. And then I've also cited Harris and Harris, where Lord Justice Thorpe referred to this and referred to the fact that this is at paragraph 8 of my supplemental note. He said at paragraph 19 of Harris and Harris, again, I don't think I need to take you there unless you'd like me to, that the court has jurisdiction to use this common law power flexibly and imaginatively in order to meet a particular practical problem, but plainly the common law power is not unlimited. And so this power needs to be exercised in accordance with principles set out in the case law. It is probably the most powerful power of the civil courts, but yet the authorities do not show clearly that there are clear principles that are applied when imposing positive conditions. There's reference in Lady Hale's judgment in Griffin and Griffin to the fact that the order would need to be a precisely defined order, but there's no discussion of exactly what power the court has to place positive conditions on a suspended sentence. Now, I don't maintain what I said at paragraph 11, that there are no authorities, because my learned friend has diligently found some authorities with positive conditions. And as I said earlier, my submission about that is that in those cases, such as Wright and Rogers, the court is dealing with a proven contempt, not to do, for example, to clear the driveway or to make sure the trees are cut down. There's a clear contempt which has been proven, and that then forms the positive condition which the court deals with. It's not, as in this...
It's not a positive-negative distinction. It's a distinction based on the preceding order or the proven
It's based on the
contempt.
preceding order, exactly, my lord. And I think that's a principled way to look at what happens. I'll leave the cases about documents for a second, because there is a more complicated point about the effect of Part 71. But just looking at those other cases where there are positive conditions, the the conditions relate to what it was that was originally ordered to be done. And that, as I've said in the section at the end of my note, that's perhaps an attractive way of looking at it, because it can then be seen as relating to the purging of the contempt. Because if you're found in contempt for something, doing the act which you failed to do would be said to perhaps wipe the slate clean. So I can see that there is.
Just explore that one moment. I'm afraid I haven't looked at Wright and Rogers. So the order in Wright and Rogers was, I've got, is it tab 21, isn't it?
It is. Yes.
The original order said what?
The original order.
Is this paragraph 1?
Yes, it's paragraph 1. So it's to remove obstructing plants, wheelie bins, obstructing the claimant's right of way over the joint drive, and then to ensure that the said trees are maintained so as to avoid further trespass.
Yeah.
So I accept those are certainly positive requirements.
And the contempt application alleged breaches of.
Yes, it alleged that there was a continuing obstruction, continuing trespass. And the point there is that there was originally an immediate sentence for that.
So just at that stage, if we take, say,
So this is paragraph 26.
6 of the application, presumably, no effort has been made to remove or pare back the tree in breach of the order 2 in paragraph 1.
Indeed, my lord. And paragraph 26 of the judgment of page 410, the committal application identified the breaches of the order for which a sanction could be imposed, and so those were the acts which obstructed the use of the right of way. And what happened was the judge had imposed an immediate sentence, but on appeal, it was held that as the purpose is to secure compliance, that sentence should be suspended on condition that these were complied with. So
it wasn't just a matter of remedying the particular breaches; it was a matter of complying with the orders that had been broken.
It was a matter of complying with the orders insofar as these were proven contempt. There was an order with a penal notice requiring this to be done. It wasn't done. The contempt was then found, and then the order, following the appeal, the order was suspended with conditions essentially that should be complied with.
So can I just understand, if we take what we saw in little 2 at 1, which is removing all parts of overhanging trees and ensuring that they're maintained, we see that the breach that was alleged was failing to pare back a particular tree.
Indeed. And then it's paragraph 32 is the order that's made on appeal.
And so, what does that say?
So that's the judge. The court then imposes a suspended order, suspended for 12 months, on condition that the removal of all obstructions from the driveway is carried out.
Well, I don't think that's entirely 100% accurate. You're right, that is what was required, but the conditions are that Little Roman 1, a pre-existing order was complied with. Little Roman 2, the same pre-existing order was complied with in every respect. All Roman 1 does is say it's the obstructions to the driveway.
Indeed, my lord.
Roman 2 says all the other parts of the order. In other words, you have to comply with the pre-existing order. And 3 is effectively a description of what would happen if neither of those, unless both of those conditions are complied with.
So it's not just cutting back the particular tree. You have for the future to ensure that the trees are maintained so as to avoid trespass.
Indeed, and I think every case is going to have some fact-specific consequences. Plainly dealing with the obstruction of the driveway, there could be all sorts of foliage or other new causes of obstruction. So the order is saying that these need to be removed, and then the defendant has then to comply and to make sure that the earlier order is complied with.
Exactly. In every respect is the phrase used. Isn't
It is. So the other parts, there were some negative conditions that she mustn't by herself or her servants or agents obstruct the driveway,
Payment of the costs.
and she must pay the costs. That was part of the original order, so that would fall in there.
That
But I
bit I'm
think
not surprised by, because you can't go to prison for
Well, I was
failing to
going
pay debt.
I was going to say, my lord, that does fly in the face of that principle, and there's another authority in the bundle where there is a requirement to repay a sum, which my learned friend had. Is that Crystal Muse? There is a requirement, yes, where Mrs. Metrick her sentence was suspended on condition that the sum of £5,000 was repaid into her frozen account. But that does come very close to imprisoning somebody for debt. I don't know whether that point was made there, but clearly that is a principle that I think it would be difficult to sustain a condition that somebody must make a payment as a condition of avoiding court, of avoiding a sentence of contempt being activated.
The short point on Wright and Rogers is paragraphs of the original order that hadn't been complied with formed part of the conditions imposed on suspension.
Indeed, yes. Yes, that is what the
Difference
judge
here,
said.
I think, the difference here, so far as I understand it, as you say, the conditions that are imposed must relate to the contempt itself, the application itself.
Indeed, my lord.
Is that right?
That is right, and that's why I say there's a principled distinction.
Yeah.
And I accept there's no decision. There's some comments in the judgment, but there's no decision one way or the other about Mr. Windhorst's production of documents. It's obviously a factor the judge is entitled to take into consideration when considering sentence. But in my submission, it goes too far to require compliance with that as a condition of the sentence not being activated when it's not been found that there is an underlying contempt there at all. A creative litigant could no doubt think of all kinds of positive obligations they would like to impose on somebody, and the court needs to step in and make sure that there is a principled approach to this. And my submission is that it should be linked in that way to the contempts that are in fact proved to the criminal standard. Now,
Just thinking around that for a moment. In terms of your condition D, the one that's at issue here, as you say, there would have to be an application to activate the suspended sentence,
yes, my lord.
in which it would be alleged that you had not complied with condition D on this hypothesis. And it would then have to be proved to the criminal standard that you had failed to comply with condition D.
I think the court has a discretion to revisit the entire matter at that point. So the court does not necessarily, it's not an automatic activating of these.
No, I follow that, but I mean, you say you referred to proving to the criminal standard, but you wouldn't get into activating the suspended sentence, presumably, unless you proved a breach to the criminal standard of the condition.
I think that must be right, my lord, yes. Yes, because I think the court is exercising a similar jurisdiction to the one it's exercising the first time around. So yes, it would need to be satisfied so that it was sure that the condition had been breached. And I accept that is a safeguard that is built into this regime. But nevertheless, the court has to be careful when imposing the condition in the first place. I don't think it's right that the contemnor is at the mercy of that process from the very beginning.
I think in technically pedantic terms, you'd have to prove that the condition had not been complied with,
I think that's correct, my lord, yes.
not that it had been breached.
No, indeed. Yes, no, I completely accept that. It's necessary, my lord, to say something about Part 71, because that doesn't fit neatly into this. It doesn't fit neatly into it either way, because what it says is that where somebody...
Should we just turn that up so we can see?
Certainly,
what
Part
it does
71 itself.
say? Yes. 71.8 really, is it?
Indeed. Yes, let's see. Yes, so 71, do you have 71.8, my lords?
Yes.
I'm grateful. No, 71.8 is it responds to 71.2, so there has to be a breach of an order made under 71.2 in order for that to be activated. So when there is a failure to comply with an order under 71.2, then the court will refer the matter to a High Court judge, and the judge may, provided certain requirements as to service and offering of conduct money, may hold the person in contempt of court and make an order punishing them. And if the order is made, no matter what kind of punishment is, the judge is required to, or will direct that the order shall be suspended, provided the person attends court at a time and place specified in the order and complies with all the terms of that order and the original order. So that gives the judge no discretion about the order to make. The judge is required to suspend the sentence and is required to attach those two conditions to it.
There's no discretion as to suspension. As to 3A2, complies with all the terms of that order and the original order. The original order presumably is identifiable.
That will be the order requiring the person to attend court and probably to produce documents at the hearing.
And perhaps in a moment you could identify that order for us. But
yes, it
complies
is
with all the terms of that order. What restriction is there on the terms of that order?
Well, in my submission, when the rule refers to the original order, it presupposes that is going to be an order within the scope of Part 71. And I say that because in the Seam case, there was an order which Mr. Justice Bryan decided wasn't within the scope of 71.2 because it was an order to produce documents at a time that was much earlier rather than at the hearing, which is what Rule 71.2 requires. And so he decided that wasn't a rule within scope, and so...
So I followed that, but little 2 refers to complying with the terms of that order and the original order. So what restrictions are there on the terms of that order as opposed to the original order?
That order is the order that the court makes holding the person in contempt. And then the original order is the original Part 71 order. Although that's how I read it.
So let's just take a hypothetical situation. Suppose the original order had said you have to attend and had said nothing at all about documents. The person doesn't attend, it's referred to a judge. The judge has to make an order which is suspended. It's to be suspended provided that the person complies with the terms of the original order, which is attending, but also complies with the terms of that order. So can the judge in that order put in a term, you have to provide documents?
I think, my lord, this point was considered by this court earlier this year. There's a decision in the bundle in Deutsche Bank where Lady Justice Andrews was dealing with the question of whether or not the court could, once it was dealing with a Part 71 application, list further hearings, whether it was necessary for a party to say the examination is over and we will now seek contempt, or if they can keep the process going and ask the court once it's seized of it to make further ancillary orders. And Lady Justice Andrews and the court agreed, decided that that was within the court's power. So it wasn't necessary to make a separate Part 71 application for each hearing. The court could then, in exercise of its powers, direct further hearings and make further ancillary orders. And
so just to be clear, under 71.8(3), can the judge include as a condition, say as to documents, something that was not in the original order?
My lord, no, I don't think that's possible. I think my reading is that the judge will direct that it's compliance with the order, which is the order holding the person in contempt, and then complying with the original order, which is the order requiring attendance and possibly documents.
So what would the terms of the order holding the person in contempt be?
That would be the order suspending sentence on condition. It's
Well, no,
self-referential.
it would be, wouldn't it? Making the order punishing them by a fine, imprisonment, confiscation, etc.
Indeed,
So-
my lord. Yes.
That is the order, and then there's a second element to it that it's suspended.
Indeed, my lord. And
Because 71.82 says hold the person in contempt of court and make an order punishing them.
indeed,
So the answer to my lordship's question is, I think, that order would be holding them in contempt, imposing the punishment, and then suspending it. And the original order must be anything that they were ordered to do under 71.2.
indeed, my lord. I think that must be right. And so complying with all the terms of that order is complying with the terms of suspension, which includes the term that the original order is complied with.
Well, I'm not sure you need to add that part
No.
because you've got to comply with the original order as well. I mean, if I may say so, the purpose of this rule, whether it applies, whether it achieves its purpose or not, let's put that to one side. The purpose of it is to ensure compliance by the contempt law with whatever they've been ordered to do already.
Indeed, my lord. Yes,
That's logical, isn't it?
it is. That's the purpose of the rule, to ensure that the court's processes are followed, and when somebody's directed to attend, they attend. The answer
No,
goes to
but without restricting it just to directed to attend. When somebody's been ordered to do something, whether it's attending or producing documents or any of the other provisions in 71.2, that they in fact comply with that order. And if they don't, then they can be brought before the court under 71.8, which heading is failure to comply with order.
Indeed, and I think the order they are failing to comply with is the Part 71 order. I don't think that if there were other orders requiring other obligations, such as in the Wright and Rogers case, I don't think it would be possible to attach those obligations to an order under 71.8. I think 71.8, I would submit, is dealing only with the requirements of Part 71 and orders made under that part. I don't think it would be open to a court to suspend sentence on conditions outside of that regime. I think if those orders are not being complied with, then the proper route is a Part 81 application for contempt. If there's another order with a penal notice that's been breached, I don't think, but I would submit it's not possible to use Part 71 to enforce other orders, and that's why I say there's a difficulty when if a judge makes an order that's not under Part 71 as a condition.
You say they'd have to use 81.
I say they'd have to use 81.
Yeah.
But the reason Part 71 is needs addressing separately is because it doesn't follow my principle that you have to link it to a finding of contempt, because on its face it says that the original order needs to be complied with as well. There may not be a breach of all of the terms of the original order, but they are then attached as conditions of sentence under in the suspended order. And so it does go further than what I say the position should be. And I think you can explain it by saying that Part 71 is a principled exception to that. It creates unusually an obligation on a witness to attend court, which isn't otherwise present in the common law. It's a new creature of the CPR. And I think it is a principled exception because it has the purpose of enabling compliance. But I accept that it doesn't completely follow my principle, because you could have a situation where there hasn't actually been a breach of what's referred to as the earlier or the original order, but nevertheless you're required, or the judge is required to direct that that's a term of suspension because the order is in mandatory terms. It doesn't give the judge the option to add that or not.
Can I just explore it a moment? So suppose you have an order made under Part 71 requiring a person to attend and to produce at court documents in his control,
Yes,
which is quite possible as I understand it. Suppose then he doesn't attend, and so a contempt application is made on the basis that he failed to attend. The judge makes a committal order but suspends it, it's obviously suspended on the basis that the person then attends. Is it possible for it also to be suspended on condition that when he does attend, he produces the documents which he has, even though that wasn't part of the contempt application?
I think so, my lord. Part 71.8 is designed to work as a court-led process where the court will refer the matter to the High Court judge, and presumably that would be at the hearing. These hearings are sometimes conducted by court officers who are not judges. So the rule is set up so that there would be a reference to a judge to look at the point. And the judge is then going to decide and may hold the person in contempt. So they're going to analyse it. But I accept that what the judge may decide the person is in contempt for not attending, but make no specific finding about whether they're in contempt for not producing documents. But nevertheless, the rule requires suspended sentence with all the conditions of the original order, which would include documents. So that's why Part 71 is outside this principle. But in my submission, that's very different from a situation where a positive condition might be attached to as a condition of suspending a sentence that's not related in such a principled way as it is under Part 71.
And just coming back then to this case, you say the judge couldn't have imposed condition D under Part 71 because although an earlier order had indeed obliged you to produce documents, it obliged you to produce documents in advance of the hearing instead of at the hearing. Is that the point?
The original order did require production of documents at the hearing, but the condition is to provide documents in advance of the hearing.
I see, yes, I see.
So that's not complying with the terms of the original order, that's going slightly further.
So if it were varied to say you have to provide them at the hearing, that would be all right.
Assuming the judge is then making a Part 71 order, yes, I have to accept that that's how the judge makes that order.
Yeah.
And so, indeed, that is how it would be applied to this appeal, and it has a similar result to ground 2 in that it is uncoupling the documents requirement from the sentence.
So, just so that I can understand that submission, the part of the condition to which you take effectively some sort of a jurisdictional objection is that the order relating to the documents has to be produced before the hearing. Is that right?
Indeed, yes. It's not less than 14 days prior to the date of the
So if it
examination.
had said so just assuming my lordship's clarification, if it had been at the hearing, there's no jurisdictional issue.
There's no jurisdictional issue if there's an order under Part 71, Rule 71.8. In my submission, Part 71, Rule 71.8 is a separate confined process which requires...
I do understand that.
But if she's making an order under Part 81, then it's a positive condition which I say there's no jurisdiction for because there's no finding of contempt in respect of it.
I mean, if
I do accept the point that if it's a Part 71 order and the order is to produce documents at the hearing rather than 14 days prior, then that would be within 71.8.
Well, why does 71.8 mean that it's got to be at the hearing? Or is that because of the way the
That's because of the way that
was turned?
That's because of the wording of 71.2, and that was what Justice Brown was dealing with in the Seam case. The requirement is that the documents are produced at the hearing,
Oh, I see.
so in order for there to be a breach of that condition, the order must specify that the documents need to be produced at the hearing and not in advance. And this is an instance where parties are using this process to try and obtain additional benefit to streamline the process, and I think the court needs to confine it.
And this is because of the wording of 71.2 subpara 6b.
It is, my lord.
When
yes.
he does produce at court documents in his control.
Indeed, my lord.
So
So
that's
that,
the
and that was the decision of
So to be absolutely clear, which I think you are absolutely entirely. So under 71.26b, the court has power to order the production of documents at the hearing.
yes, my lord.
An order to that effect was made here in the Elaine order.
It was, that was an order by consent, but yes, it required.
So had the judge approached this simply by reference to 71.8, she would have been obliged to suspend, provided that the person attends at the court, which is, so you have to attend, and provided that you comply with the terms of the original order, which include the provision for the production of documents.
Indeed, that's what it amounts to, my lord. Yes. And so that, to the extent that that wasn't done, it wasn't an order that there was power to make under Part 71 because it went beyond that requirement.
Well, one could remedy that by deleting the 14-day bit.
Well, my lord, that would be one way around the issue if the order was made under Part 71, but it seems to be accepted it's made under Part 81, but the judgment itself is not clear because the judge decides that she's going to suspend sentence anyway, and I think to a certain extent it doesn't matter which way she went. That was her decision on the. She was addressed on whether she should make an order under Part 71 or 81, but there was a technical point about Part 71 which fell away with further evidence, so it wasn't relevant. It wasn't as relevant when it came to the hearing, but she did deal with the point because she could have, under Part 81, made an immediate sentence, and so it was important. It was still a point that needed to be argued. But I think, in my submission, the order she made is under Part 81 because, for amongst other things, she was sentencing for breach of an undertaking, which is not part of an order under Part 71.
But the just returning to the Appellant order, that was made by consent, as you say. The hearing for the examination was to be fixed. And paragraph 3 says the respondent at the time and place confirmed by the court shall produce at court. So why is the court not entitled to say you've got to produce them 14 days in advance of the next hearing?
Because
that's just providing clarity to how paragraph 3 was originally worded.
well, the objection to the timing is simply that if it's an order under Part 71.2, the requirement is to produce at the hearing.
No, I understand that, but as you've pointed out a couple of times, the Appellant order was made by consent.
It was made by consent, my lord, but I think in my submission it remains an order under Part 71 because it recites the application that was made and there's a requirement to relist pursuant to the Part 71 order, which is the original Part 71 order.
I see. All right.
Yes. And my lord, I think I've made the points on that I wanted to know if there's anything further.
No, that's very helpful. Thank you very much.
Okay, my lord.
Mr. McDonald.
My lord, I was going to deal with this ground 1, ground 2 and ground 3.
Yep.
Can I start with ground 1, sentence? I propose to take this briefly under 3 headings and hopefully only to supplement what's said in my skeleton. First is the relevant legal principles. Second is the appellant's suggestion that the sentence was excessive compared to a supposed tariff. And third, I'll briefly touch on Mr. Windhorst's complaints around how the judge weighed the aggravating and mitigating factors. My lords, I know will be very familiar with the principles. They're set out at paragraph 18 of my skeleton argument, which is core bundle tab 6, page 64. The leading case is FCA and McKendrick, which makes clear that the appellate court is reluctant to interfere with sentencing decisions below, and there will be few cases in which sentence is successfully challenged. The result, as identified in paragraph 19, is that a challenge to the judge's assessment of severity is very difficult to sustain. And then I also refer at paragraph 20 to Lord Justice Newey's helpful comments in the Kawaja case, where he makes the point that it is seldom useful to cite other cases, precisely because the judge's function is not to identify similar features with other cases, but to assess the seriousness of the conduct in the context of the instant case, and there are many other authorities making the same point. Can I ask you to turn up one recent authority which post-dates my skeleton, but which is, I hope, helpful, which is the Khan Authority in your further authorities bundle at tab 22. Tab 22, starting on page 413. And as your lordship sees from paragraph 17, which is at the top of page 416, this was an appeal against a 6-month immediate imprisonment. And then, my lords, at page 417, the lordship sees halfway down the Court of Appeal set out the applicable test on appeal. This was a decision of Lord Justices Singh and Coulson. And then over the page at 418, paragraph 31, Lord Justice Coulson identifies 3 further points to be made. And can I just highlight points 2 and 3? Point 2 is this court will regard the consideration and imposition of sanctions for contempt of court as primarily a matter for the first instance judge. In particular, all matters of evaluation, all questions of weight are a matter for them, not for this court. That's particularly true in circumstances such as this, where the appellant chose to give oral evidence, but it's said to be applicable in all cases. And then 3, on the issue of sanction, again, unlikely the appeal court will be assisted by other cases. The law of contempt so broad arises in so many different ways that the precise sanctions in place in other cases are usually illuminated. And my lord, in light of those principles, my submission to the appeal on sentence is without merit. It's already clear from those authorities that there's no such thing as a tariff in the law of contempt. Each case turns on its own facts, and that point rightly wasn't pursued orally. What can be said is that breaches of orders requiring information to be provided are treated very seriously. That's not contested. So are breaches of undertakings, and that the upper end of the scale is not reserved for the very worst cases, and the judge recited all those principles in her judgment. For what it's worth, my lords, there are numerous examples of heavy sentences being given for deliberate failures to provide information. I gave the judge below the example of Solodchenko, where 21 months was imposed for a failure to comply with the disclosure provision in a freezing order. I know your lordships will be familiar with what was said at paragraph 51, where the Court of Appeal held that any deliberate and substantial breach of the restraint provisions or the disclosure provision of the freezing order is a serious matter requiring a sentence measured in months, not weeks. And the Court of Appeal there gave the example of another case of Mr. Shalabayev, who was given 18 months. Another example, my lord, is the Asia Islamic Trade Finance case, which is tab 3 of the authorities bundle. You don't need to turn it up. It's a well-known decision of Mr. Justice Popplewell, where Mr. Dogan was given 18 months for failing to comply with disclosure provisions in a freezing order. And of course, there's no authority to suggest that breach of the CPR 71 order, which is also an order requiring the provision of information and documents to help a judgment creditor enforce a judgment, is some way less serious. And indeed, as the judge pointed out, in some ways it's more serious because by this stage, the judgment creditor actually has a judgment to enforce. Consistently with that, a heavy sentence for breach of a CPR 71 order was imposed, of course, in the Vic litigation. And there, Mr. Vick had in some ways done more than Mr. Windhorst because he actually attended the Part 71 hearing and he actually provided documents in advance of that hearing in accordance with the order which required documents to be given 14 days before. But what Mrs. Justice Mulder upheld by the Court of Appeal, was that he had lied in material respects in his evidence and he had failed to provide material categories of documents. And she ordered a 20-month sentence imposed. That was upheld by the Court of Appeal, who described the appeal on the length of sentence as hopeless. And the reference for your lordship's note is authorities bundle, tab 11, pages 245 to 246, paragraphs 120 to 125. So any suggestion Mr. Windhorst's sentence falls outside the range is utterly fanciful in my submission.
You just remind me of the tab number, I'm sorry.
Yes, it is tab 11 of the main authorities bundle, my lord. Just briefly addressing you on the 2 cases Mr. Windhorst relies on, Jimenez and Farrer. Jimenez doesn't much assist the court. In that case, Mr. Jimenez was liable under a judgment debt for about £5 million. He failed to attend a CPR 71 hearing, and his failure was referred under the automatic procedure in CPR 71.8 to the judge. And the judge then made a suspended sentence, suspending on the usual terms an order for committal for 60 days. But that was a case where obviously the judge was just dealing with it in the ordinary course. He had not received any submission from the parties, unlike Mrs. Justice Dias in this case, or Mrs. Justice Mulder in the Vic case. And there is no discussion in the judgment of why he imposed that sentence. The whole of the judgment is in fact concerned with a different matter, which is whether various conditions of suspension were complied with. Farah is again a case on its own facts, but there the amount at stake was much smaller. It was $200,000 in unpaid solicitors' fees, and there the contender actually attended the hearing. So one needs to focus on the seriousness of the breach in this case. Standing back, this was, as the judge held, a case of a deliberate, cynical, unremedied breach of a court order and an undertaking requiring the provision of information for which no adequate apology had been given, for which Mr. Windhorst's culpability was high, the harm caused was high, there were significant aggravating factors and no mitigating factors. And that puts the case plainly at the upper end of the scale. And if your lordships did need a steer, I would suggest the most closely analogous case is Vic. My lord, there is also a complaint about the judge's weighing of the various factors. That is dealt with in paragraphs 23 to 30 of my skeleton. I don't propose to go through that all again, not least because almost none of those points were made orally. Just 2 points for your lordships. One, weight, as I've already shown you, is a matter preeminently for the first instance judge. The judge made no error at all in her analysis. And secondly, the only complaint dealt with orally was the suggestion that Mr. Windhorst was being effectively sentenced for previous breaches. I deal with that in paragraph 31 of my skeleton. That is, in my respectful submission, completely wrong. What the judge did was to sentence Mr. Windhorst for the particular breach, but to regard the pattern of evasion and game playing as an aggravating factor. And that is plain from paragraph 44 of her judgment, where she refers to that principle, quotes, by way of aggravation. And it is well established that the judge is entitled and right to do that. And the reason for that is that the previous delay and game playing meant it was even more important that Mr. Windhorst attended the hearing before Deputy Master Fine, given the delay he'd already engineered. So it enhanced the harm and the culpability and the prejudice. It was actually accepted by my learned friend that the history was relevant. Just for your lordship's note, that supplemental bundle 10, page 267, lines 5 to 9 of the transcript. And can I just show you one authority on this, my lords, which is the Stefanova decision, which is tab 13 of the main authorities bundle. This was an appeal from a committal order imposed by Mr. Justice Richard Smith, and your lordships see that at paragraph 1 on page 285. And if you turn to paragraph 25, which is page 289, you'll see 3 grounds of appeal were argued. Ground 2 was that the judge erred in taking account wider allegations of misconduct. And then you see in paragraph 26, Lord Justice Newey says in the third sentence, I don't think there's anything in the other grounds, which includes this ground. And then in paragraph 27, he says, as the context makes clear, what the judge said had to be read with the immediately preceding paragraphs. These do refer to some of the wider context, but they do so for the purpose of assessing the seriousness of the breaches and assessing the degree of harm. And that was precisely the same context that Mr. Justice Dias referred to the context in this case. And then you see Lord Justice Newey's finding at paragraph 28. He says that the suggestion is not made out. Rather, what he was saying was that one cannot assess the true seriousness and risk of harm involved in the contempts that had been established, being either admitted or found by him, without placing them in the wider context of the conduct of the litigation as a whole. That seems to me entirely appropriate and not to involve any error of principle at all. My Lord, subject to any questions from your Lordships, that's all I wanted to say on sentence. Can I then turn to ground 2? If it's acceptable to your Lordships, I was going to deal with it in reverse order. So I was going to deal first with the question of whether the order should refer to all documents or just categories, and then secondly, in whose control the document should be. The starting point, my Lord, on ground 2 is that the decision to impose conditions, as I'll show you perhaps when we get to ground 3, was an exercise of the judge's discretion. She decided on what terms it was appropriate to temper justice with mercy, and therefore on what basis she was prepared to suspend the sentence rather than imposing an immediate sentence. And it does need to be borne in mind that she was being merciful. She had found a very serious breach. She could have committed Mr. Windhorst instantaneously there and then under CPR 81, which was the provision the application was made under. But she chose not to. She gave him another chance to comply, and that's why she made the conditions. So they were an exercise of discretion. And because they're an exercise of discretion, it's of course necessary for Mr. Windhorst to meet a very high bar to succeed on appeal. I know your Lordships will be very familiar with the principles on judicial exercises of discretion. They were recently reiterated by Lady Justice Andrews in the most recent instalment of the Deutsche Bank v. Vic litigation, which for your Lordships note is further authorities, tab 26, paragraph 80 on page 496. She refers there to the formidable challenges faced by a party seeking to overturn a judicial exercise of discretion. The condition requiring disclosure of all documents was in that context an entirely appropriate exercise of discretion. As my Lord Fraser has already noted, it was in fact doing nothing other than requiring Mr. Windhorst to do what he was already obliged to do. The terms of the Appellant order, which are Supplemental Bundle tab 3, page 94, starting on that, provide for Mr. Windhorst to produce at court all documents in the defendant's control. That was a consent order. It was agreed by Mr. Windhorst. It's never been appealed. It's unquestionably binding on him, and he was obliged to comply with it. And can I just show your Lordships one other point on this order which may be relevant? If you turn it up in the supplemental bundle, it's tab 3, starting on page 94. If we look at paragraph 3 of the order, that's the requirement to produce all documents in the defendant's control. And as my Lord Fraser noted, it's a requirement to produce the documents at the time and place confirmed by the court. And that time and place was the fine hearing on the 6th of June 2025. So this is an obligation on Mr. Windhorst to provide the documents in June last year. And he should have complied with that obligation then. So I make this point just in advance of when we get there. What the judge was doing in her suspended order was, in fact, extending the time for him to comply with that order. She could have said, well, you should have given these documents in June 2025. You didn't. Give them right now on this day. But she didn't. She exercised further mercy and gave him an extended period of time to do so, namely 14 days before the restored examination. So in fact, she was requiring him to comply with this order, but giving him more time to do so. One other point to make, my lords, just over the page, on SB 97, you'll note the undertakings and undertaking 3, the respondent shall not raise any jurisdictional objection to the court's order under CPR Part 71. So to the extent Mr. Windhorst seeks to do so, it's not open to him to suggest this order was wrongly made in any respect. As I know your lordship will have well in mind, that was the third of a series of consent orders which Mr. Windhorst had agreed to, and all of which contained document disclosure requirements on exactly the same terms, requiring all documents in the defendant's control to be produced relevant to payment of the judgment debt. It was preceded in particular by the consent order of Deputy Master Marzek, 7 November 2024, which for your note, supplemental bundle, tab 3, page 91. And before that, by paragraph 6 of the consent order endorsed by His Honour Judge Appellant KC on the 15th of May 24, supplemental bundle, tab 3, page 84. So 3 times Mr. Windhorst has agreed to these precise disclosure requirements. And just one other point to make on this. The 2 preceding orders, so the Marzek order and the Pelling order, were made whilst Mr. Windhorst had solicitors on the record. And those solicitors were Avogard LLP. They came on the record in February 2024 and off in January 2025. So we respectfully submit it is untenable for Mr. Windhorst to complain that the condition imposed by the judge is unfair when it is only seeking to require him to do what he has already agreed to do by consent, not once, but 3 times. This is, in our submission, in reality, an extension of the strategy of delay and evasion, because Mr. Windhorst, having agreed to those orders and agreed not to raise any jurisdictional objections, now wishes to be let off by having the obligations in those orders watered down. And that is not tenable. It would undermine the administration of justice. The other point I want to make on this, my lords, is that the requirement to provide all documents relevant to the matter in issue is a common feature of CPR 71 orders. And can I just give you a few examples of that? The first is in the supplemental bundle at tab 3, page 46.
Sorry, supplemental.
Supplemental bundle, tab 3, page 46, my lord.
Order to attend for questioning.
Exactly, my lord. So this is the first order under CPR 71 made against Mr. Windhorst by Master Cook. And you see from paragraph 2, the officer at that time and place produced a called all documents in the judgment debtor's control. And then if your lordship turn on to page 48,
Yep.
At page 48 is the standard information that usually features at the back of a CPR 71 order. And you see under the heading documents in your control, you must produce all documents which confirm the information required. If you don't have them, you must get them if you can. And then there's a list of documents with bullet points. And if you go down, it says if you've got a business or you're a partner in the business, or the judgment debtor is a company or corporation, they will include the above documents so far as they relate to the business. So provision of all documents is not just at each of the 2 consent orders, but a common feature of a CPR 71 order itself. The same provision was also contained in the CPR 71 order in the Vic litigation. If your lordships bear with me, I'll just show you that because it may be helpful for you to have it. It's authorities bundle, tab 12, page 248, main authority. This is a decision of Mr. Justice Henshaw. It's not directly on point, but it helpfully sets out some of the terms of the previous orders. And if you turn to page 252 at paragraph 12, Mr. Justice Henshaw there recites the order made under CPR 71, and you see at 12.1 it required Mr. Vic to produce by 14 October 2015, that's 14 days in advance of the hearing, all documents in SHI's control which relate to SHI's means of paying the amount due under the judgment and judgment order. And so again, another all documents order, and actually again referring to the judgment debtor rather than referring to Mr. Vic himself, SHI being Mr. Vic's creature company. Same true in the Jimenez case, my lords, if you've got your authorities file. If you turn to tab 15, at page 309, and paragraph 13 sets out the Part 71 order made by Deputy Master Rees against Mr. Jimenez. In this case, obviously, Mr. Jimenez was personally the judgment debtor, so it's an order against him. And you can see from the second sentence, the Deputy Master also ordered the defendant at that time and place to produce a called all documents in his control, including but not limited to those set out in a list. So all documents, an entirely standard feature of CPR 71. Not only was it orthodox, the judge's reasons for making order in those terms were very clear. I'm not going to take you to it, but my lords, they can be found in the transcript of the consequential argument, which is in supplemental bundle tab 10, page 272. And if your lordships take a moment and you have time to read pages 112 to 113 of the transcript, you'll see the judge made 3 points. She said, firstly, the condition is simply repeating the obligation that Mr. Windhorst is already under. And secondly, there are sufficient safeguards in the order. And safeguard number one, as my Lord Newey noted, is that there has to be an application. That's Villiers and Villiers. So there has to be another application before any sentence was activated. Safeguard 2, worth noting, the order also contains liberty to apply by Mr. Windhorst to purge his contempt.
There's a sort of oddity about the relationship between purging contempt and a suspended order.
Yes.
So the judge has said 18 months, 9 months of that can be got rid of by purging. But of course, if you fulfil the conditions, then it goes anyway.
It does. Your Lordship's absolutely right. I think, to be fair, the judge was attempting to follow the sentencing guidance in the authority that says you've got to divide your sentence into the two halves, and you should give the sentence before you then decide whether to suspend. So it does. I agree with that. But to be fair, I think she was actually trying diligently to do precisely what's been required of her by the authorities. And in a sense, it would remain relevant because if Mr. Windhorst didn't comply and his sentence was activated, he would still have the opportunity of purging, and then that 9-month point would be relevant there.
Although that isn't in the order, the 9-month point, it's
Yes,
only
it is
in the
not.
judgment.
But that's why it would still remain relevant. Yes, on all documents, therefore, judge's decision clearly reasonable. The other point to make, my lord, is there's significant prejudice to my client from a categories-based approach. I spelt out the reasons for that in paragraphs 58 and following. But first and foremost, CPR 71 is a process designed to enable the judgment debtor to obtain the information it needs to make decisions about enforcement. It's not a game of battleships where the judgment creditor has to guess what documents the judgment debtor has, and that's why CPR 71 orders are often framed in an all documents way. Second, the judge has already held that Mr. Windhorst is not an honest man and has already done everything in his power to avoid providing information and documents. She also held paragraph 49 of her judgment seems likely he would put assets out of reach. So the court was faced with a dishonest individual who sought at every turn to avoid giving information. It's therefore plainly appropriate to require all documents to be produced so that my client gets the documents entitled to and so that the restored examination is effective. And indeed, it's likely to be the case that only Mr. Windhorst actually knows where the relevant documents are. Your lordships may want to bear in mind as well that having sent him the letter that you were shown earlier, saying these are the categories you want, we've had no response. So it's not a case where Mr. Windhorst has come to the court and said, look, I've got these documents, these are the ones, why don't you live with those? He's just not engaged. So there is a very real risk that absent all documents, key documents will be missing and we will never find out. We also know that Mr. Windhorst has the documents because he has not engaged with the bankruptcy trustee. That was a clear finding made by the judge, and it is supported by the evidence. So it's quite clear the documents are lying with Mr. Windhorst, not the bankruptcy trustee.
And the bankruptcy trustee, as I understand it, has expressed happiness that this matter has proceeded with.
He has, my lord, and he's also said, and it's actually set out in the 6th affidavit of Mr. Hooker, which is in your supplemental bundle. He's also sent some more recent correspondence saying essentially to date, Mr. Windhorst has not engaged. He has not complied with his obligations to the estate. And just to give your lordships the reference to that, it is supplemental bundle tab 6, paragraphs 13, 14, and 16, page 200. The bottom line is that Mr. Windhorst has not engaged in any way. As to the suggestion that the disclosure exercise would be unfair, well, he's got solicitors on the record. They can help him and they can guide him as to what needs to be produced. There's plainly zero prospect of him being committed for honest mistakes or minor oversights, and it would be grossly disproportionate to bring an application seeking to do that. One other point, my lords, just quickly on this. In paragraph 33 of Mr. Windhorst's skeleton, it suggested that we should ask for categories, and then if further documents appear to be relevant, well, we can just apply to adjourn and restored hearing. That's obviously unacceptable. There's been too much delay already. My lord, that then brings me to ground 2A, which is whether the order should refer to documents in Tenor's control or documents in Mr. Windhorst. In my submission, it's basically the same points. First, by referring to documents in Tenor's control, the condition of suspension is simply replicating the obligation Mr. Windhorst is already under pursuant to the Appellant order and all of its predecessors. And nothing conceivably unfair about that. Second, any challenge to that condition is a challenge to the judge's exercise of discretion. And third, it's clear in any case that the order should refer to Tenor's documents, not Mr. Windhorst. And the obvious reason for that is that it's Tenor that is the judgment debtor. And the obligation on Mr. Windhorst under CPR 71 to attend and give evidence and provide documents arises from his status as Tenor's director. And he is being required to provide the documents of Tenor, not documents in his private capacity. And there's an obvious risk that if the order refers to Mr. Windhorst's documents rather than Tenor's, we may be met with all sorts of arguments that, well, I've got no personal obligation to disclose anything at all. And that's precisely the point we're concerned about. And indeed, we've already met such an argument because Mr. Windhorst's original position was that none of Tenor's documents are under his control anymore by virtue of the bankruptcy process. And we know that to be untrue. It's precisely that sort of game playing we are worried about, and that's why the order needs to refer to Tenor's documents, not Mr. Windhorst's. And again, that's consistent with the previous orders. It's also, again, consistent with the Vic litigation where I showed you the order was for provision of SHI's documents. I'll give you one other reference on that. When Mrs. Justice Mulder came to consider the conditions of suspension, she actually considered an argument by Mr. Vic that it should refer to documents in his control, and she determined no, it should refer to documents in SHI's control. And the reference to that is Further Authorities Bundle, tab 25, page 476, paragraph 82. Obviously, the order shouldn't require Mr. Windhorst to do the impossible. No one on this side of the court is suggesting Mr. Windhorst would be in breach if he genuinely could not obtain a document, and the order would never be construed as requiring him to do that. And can I just show you on that one point in the Jimenez case, which we looked at before, and is paragraph tab 15 of the authorities bundles. If your lordships turn tab 15, page 342. Page 342, and then can you see the heading, has the defendant complied with Master Marsh's order for the production of documents? And the judge goes on to consider whether he has complied and whether a bench warrant should be issued. And you see at paragraph 128, he recites the requirement to provide copies of the documents. And then over the page, my lords, page 343, the judge recites the rest of the order, and then he comments on it in the paragraph in the middle of the page beginning, it is unlikely that. And can I just ask your lordships to read that paragraph, which finishes, but without success? I submit the same approach would apply here. But in any case, we're happy to.
So I'm sorry, I'm being a little slow. I don't quite understand your point.
Sorry, my point was simply, my lord, that the order would never be construed as requiring Mr. Windhorst to hand over documents he can't get hold of.
Well, that's inherent in the word control.
So we were happy to include a clarification to that effect in the order. Okay. So that's all I want to say on ground 2, unless your lordships have any further questions. And that then just takes me to ground 3 and the new arguments, which morphed somewhat, I think, this morning. Just as a starting point, my lords, I think it's just helpful to have in mind the various jurisdictional provisions. So we've got Part 81, that is the general committal procedure. That was the principal part under which this application was made. And it's clear from the judgment that Mr. Justice Dias was applying those principles. There's then Part 71.8, which is a summary court-led procedure, which we sought the order under in the alternative. And as I'll show you in a minute, both of those, 81 and 71.8, are just procedures. They do not create or affect the substantive law of contempt, which is a common law power. And there's Court of Appeal authority on that, which I will show you in a minute. And the key difference between 81 and 71.8 is 71.8 is summary, and it's for that reason that the order has to be suspended. Whereas 81 has a much longer process led by the parties where evidence is exchanged, grounds of contempt are put forward, the trial is held, and therefore there are sufficient procedural safeguards that the court can proceed to commit immediately. So those are the two different provisions, but they're both just procedures. And therefore the court's power to suspend must be the same in both cases. And the key point to start with is that the court's power to suspend is a common law power. That's common ground. That's paragraph 2 of my note of Thursday and paragraph 9 of Mr. West's note. As to what that power is, Mr. West and I both agree that it is encapsulated in the old RSC Rule 52.7 and the old CPR 81.29. And that is a power to suspend on such conditions as the court may specify. So it is a unlimited discretion, limited only by the usual requirements of the exercise of judicial discretion.
You say encapsulated, but you also say, well, actually, it's all back to the common law.
Absolutely. But the point is that the way that those provisions are helpful is that they encapsulate or articulate what the common law was.
Is.
And indeed, in the case of Lee,
I think you mean what the common law is, because it remains.
quite right, my lord. I apologise, I misspoke. I should say what it is. And that is reflected in the case of Lee. And I think it is worth turning this up. It's in the Further Authorities Bundle, tab 17, page 374. And your lordship sees at just below E, page 374, it says we don't accept RSC 52.7 conferred a new jurisdiction upon the High Court. In our view, the context of the rule was procedural and prescribed the procedure for the exercise of a power of suspension of committal orders which has never been doubted. So no suggestion in any way that that articulation of the power as set out in the RSC is in any way wrong. Instead, it's said to reflect a power which has never been doubted.
Well, you couldn't confer jurisdiction on the High Court just by drafting a rule anyway.
You couldn't, no, exactly. The rule simply just helpfully sets out what the existing common law jurisdiction is. And that's also reflected, my lord, in the case of Crystal Muse.
I mean,
and Metro.
just before you go there,
Yes.
I haven't read on, but at this point, Lord Justice Cumming Bruce explains, well, how that's done is by having the order lie in the office.
Yes.
And that's obviously not, not what's happening here or in the other cases.
Well, actually, to an extent, it is, my lord, because if your lordship looks at the draft order,
As lying in the office.
it has lying in the
It does it,
office.
I see.
So what it essentially says is that the order is suspended and the warrant shall lie in the court office for X period, provided you do A, B, and C. And then if you don't make an application by the deadline, then the order for committal is discharged
Yes, I see.
Or it's expired.
or expired.
But that, in a way, that's the, I mean, this is the crucial difference between exercising the common law jurisdiction to suspend, which is the court
Yep.
doing it of its own motion under its common law jurisdiction.
Exactly.
And, for example, a suspended sentence of imprisonment for a criminal offence, which is completely different and done under a statutory regime.
Precisely.
So if the warrant stays in the office and isn't executed on the person, then they're taken into custody.
Correct. Your lordship has the point precisely.
But all Liam Walker does is it articulates what I think both of you accept as correct. The fact that there was a rule, the old RSC Order 52, doesn't give the court jurisdiction to suspend. It had that jurisdiction anyway. It just used to be expressed in older, different language.
Yes,
All right.
I agree entirely with that. And the way it's expressed is expressed in terms of a discretion. And that's also the way it's reflected in the Crystal Muse case, my lord, which is tab 20, page 400. Paragraph 11, Mr. Justice Collins, as he was at the time, decision that is frequently cited with approval. Paragraph 11, the court may impose a custodial sentence, the execution of which may be suspended for such period or on such terms as the court thinks fit. So it is a common law discretionary power to suspend, and as your lordships know, in this case, the suspension was on positive conditions. See paragraph 19, where Mrs. Metrick was obliged to restore certain sums to the frozen bank account from which sums had been wrongfully pilfered in breach of a freezing order. So there has never been any suggestion, and my learned friend has not pointed to any authority or textbook suggesting that the discretionary power to suspend is limited either only to negative conditions or specifically to contempts that have already been found. And there are a plethora of examples of cases where positive conditions to suspend have been imposed, including by the Court of Appeal in the Wright and Rogers case, which you've already looked at. I've given numerous other examples in my skeleton, the Vic litigation being a good example, Kawaja being a good example, Gulf Azov and Idley, and several others. So there is no doubt whatsoever that the court has the power to suspend on positive conditions. If it were otherwise, then all of those decisions would have been wrongly decided. And not only would that be the case, but that would be, in my submission, a baleful and deeply unsatisfactory outcome, because it would entirely constrain this court's ability to police its own orders. And the obvious example of that is that where an order is made requiring compliance in positive terms, so let's take, for example, the example in Wright, you must clear this driveway of obstructions. If there were no power to suspend on positive conditions, then the court could not make an order saying, well, I will commit you, but suspend it on condition you comply with the order.
I mean, that might be unsatisfactory from the applicant's point of view. It could be unsatisfactory from the respondent's point of view if the court weren't able to suspend and instead had to send to prison.
Exactly. Exactly. I said make precisely that point, my lord. It's unsatisfactory both from an administration of justice point of view, but it's also really tough on contemners because it actually limits the court's ability to temper justice or punishment with mercy.
And in a Wright and Rogers type case, the purging might be difficult.
Yes.
I mean, you could cut back the individual tree, but
Exactly, my lord. So it would be a deeply unsatisfactory position for a number of reasons, and that's why no authority has ever suggested that such a limitation applies.
What about the link between the conditions and the contempt?
Well, Exactly.
Because,
my
for
lord.
example, you're effectively submitting, and I don't want to put words in your mouth, it can't be an unfettered discretion.
No.
The conditions that are imposed must have some link or nexus with either the litigation or the contempt, isn't it?
Yes. Your lordship's absolutely right. In my submission, the answer to that is actually helpfully found in Wright and Rogers, which neatly articulates the point in paragraph 26. And what we said there, and just for your reference again, it's tab 21, paragraph 26, which is page 410, is that principal aim of the imposition of sanctions in the case where the contempt is a civil contempt involving the failure to comply with the court order is to secure compliance with the order. The sanctions imposed should be the least onerous, which will produce that result. And that's why, in that case,
Paragraph
26, my lord, yeah, page 410. And that's why, in that case, the Court of Appeal didn't just say, do all the things you should already have done as a condition of suspension, but they also said, continue to comply with the order in all respects. See paragraph 32, subparagraph 2, during the term of the suspension. And so, my lord is quite right, it's not an unfettered discretion. You can't just impose any condition you like, and that would obviously be nonsense.
So where in 26 do we find articulation of what the link should be?
Well, in my submission, what it shows is that the purpose of imposing conditions is to secure compliance. That is the function and the purpose of imposing conditions. And it is to secure compliance.
Yes, but the sentence, I have a little difficulty with the sentence that says that. It says the principal aim of the imposition of sanctions in a case with a contempt is to secure compliance with the order.
Yes.
So that's putting the punishment element off to one side. And whether one agrees or not with the principle, at least one aim of it is to secure compliance with the order.
Precisely. my lord.
So that, as a link, means it must relate to something that the contemnor has previously been ordered to do.
That's right.
What do you say to Mr. West's point? Well, you didn't bring an application to commit on those other different paragraphs of the order. You only did it on non-attendance.
Well, that's irrelevant because it's not linked to the established breaches, i.e. the established contempt. It's linked to securing compliance. There's no doubt in this case that the order has not been complied with in respect to the document provision. His Lordship was shown the relevant paragraph of the judgment. Mr. West's own solicitors say we're going to carry out a heavy disclosure exercise. So they have admitted themselves it hasn't been complied with. And we know the reason it wasn't complied with is because Mr. Windhorst did not attend court on the date. And it has to be remembered, the order was attend court, hand over the documents. Mr. Windhorst didn't do the former, and so by definition he didn't do the latter.
I mean, on this thesis, would the position be different if there had been two different orders? The master had one day made an order requiring attendance, and the next day made an order providing for the provision of documents. It would then be a different order.
Well, perhaps, my lord, but perhaps not. I mean, in my submission, a distinction like that shouldn't matter.
I see why it shouldn't matter.
Given this is fundamentally an exercise of discretion which does mercy to the contemnor but seeks to secure compliance with the order that has already been made. But because contempt is a technical field, one can see an argument being run that does make a difference. But in a sense, that didn't happen here. We all know what the Appellant order said, and we all know it wasn't complied with.
Well, it would make a difference if at the application to commit, the judge started considering to justify a committal matters that were not in the application to commit, because obviously in terms of natural justice that wouldn't be the case, that the contemnor had come. But once the contempt has been found and one moves to conditions of suspension,
Yes.
then compliance with earlier court orders that have been breached becomes relevant, doesn't it?
It does, my lord. And I was actually going to make the point that Mr. West's argument breaks down when you encounter 71.8. Because the whole point of 71.8 is that you may have a breach, which is a failure to attend the hearing. That's your breach. And we can see that by looking at 71.8, which provides, if a person against whom an order has been made under Rule 71.2, A, fails to attend court, B, refuses at the hearing to tell the oath or answer question, or C, otherwise fails to comply, the court will refer the matter to a High Court judge. So any of those failures are sufficient to invoke this jurisdiction, including mere failure to. And as your Lordship pointed out, then the next provision is that the judge may make an order for punishment, which can include imprisonment. And then there must be a direction that the order is suspended, provided the person attends and complies with all the terms of the original order. So this is a case in which someone could not attend. The matter then gets referred up to the judge. The judge passes a sentence of committal, and the judge then suspends that sentence on conditions that a further hearing is attended and all the previous requirements are complied with, which will inevitably include the production of documents. So if it were the case that the condition has to be linked not merely to securing compliance, but to a specific ground of upheld contempt, then CPR 71.8 would be ultra vires and improper.
And just proceeding a moment more. So suppose now that Order A directed the provision of documents and a later order provided for attendance, and the complaint were made that there'd been non-attendance. How would that work with 3A2? The original order wouldn't have provided for the provision of documents. Could one nevertheless impose a condition that documents be provided in accordance with Order A?
Well, my lord, obviously that doesn't arise on the facts.
No, it doesn't
in this
arise
case,
yet.
So I'm in a sense slightly reluctant to get into hypotheticals. In my submission, however, I can't see any reason why the court couldn't make them. Because, as I've already said, 71.8 and 81 are just procedures for implementing a common law power. And that common law power gives the judge the discretion to do what is needed to secure compliance with the order that has been breached. In the context of the alternative being, send the contemnant straight to prison. So it's always worth bearing in mind that the conditions are not punishments, they're opportunities given to the contemnant to evade punishment. That's what's happened in this case. The judge has said, your breaches, Mr. Windhorst, your breach is incredibly serious and you should go to prison. And I need to teach you a lesson. But I'm willing to give you an opportunity to comply with the order. And if you do that, you won't go to prison. She's not saying, well, if you don't do what I'm telling you, you will go to prison. You can see the distinction. And so it does come back to the case that if Mr. West's argument were right, 71.8 would be a dead letter. It just couldn't work. Because it is not just requiring the contemnant to do what he has been held as a matter of contempt not to have done, but also to comply with all the terms of the original order. So it is going further than a direct contempt condition link. And I think that's actually accepted in Mr. West's skeleton. And that's what actually forces Mr. West to run the argument that CPR 71 is an exception, a statutory exception to the common law rule. He has to run that argument, because if he doesn't, his argument doesn't work. But that argument is manifestly wrong because it's not. And perhaps I can just show you the relevant authority, which is the Deutsche Bank authority. And that authority is in the further authorities bundle at tab 32. And this was a unanimous decision of Lord Justices Grace, Lewison and Leggett. And what had happened at this stage is that Deutsche Bank had applied to commit Mr. Vick for breach of Part 71 under Part 81. And you see that from page 556, paragraph 7. tab 32, my lord. And Mr. Vick said, you cannot commit me under Part 81. Your only remedy is Part 71.8. And his argument was, amongst other things, 71.8 is a specific form of statutory contempt. You have to use that. And you can see that is discussed by the Court of Appeal on page 557 under the heading Issue 1, Availability of CPR Part 81. And then if your lordship turn on to page 559, paragraph 26, you see there Mr. Vick's argument. Mr. Matthews submitted the judge had fallen into error. The committal application was brought in respect of alleged breaches of an order under 71.2. Accordingly, the mandatory regime furnished by 71.8 applied. Thought he was not free to proceed under Rule 81.4. The general couldn't override the specific, and Rule 71.8 with the lex specialis dealing specifically with the consequences of alleged breaches of orders under Rule 71.2. And then my lord's turning over the page to page 560 and letter B. Furthermore, Mr. Vick's primary position was that Rule 71.8 created a discrete form of statutory contempt. If so, the court's inherent jurisdiction could not be used to obtain an order wider than or inconsistent with it. And that argument is dismissed in the judgment of Lord Justice Grace, with whom the other Lord Justices agreed, at paragraph 35, at the bottom of page 561. He says, the source of the court's power to commit is derived from its inherent jurisdiction under both 81 and 71. And then he goes on to say he agrees with the observations of the first instance judge that both parts provide for the procedure to be followed over the page when the common law power is exercised. And you see he goes on to say he does not accept that Part 71 is a contempt of statutory origin. So if there's no power to make a condition that is linked to securing compliance but is not, as it were, a direct mirror of the ground of contempt, under 81 there also isn't under 71.8. And that's why my learned friend's arguments fail entirely. And in any case, my lords, I've already made the point that actually all the judge was doing was not going beyond the terms of the Elaine order, but actually giving Mr. Windhorst more time to comply. He should have complied back in June 2025. That's when the document should have been provided. But she extended the time for him to do so. And it's well established that the court can vary by way of amelioration. That's the case of Harris and Harris, which is Further Authorities tab 18, Harris 19 and 22. Just a couple more points, my lord, before I conclude. Mr. Justice Bryan's decision on this is not relevant. That decision holds that where a CPR 71 order is made, which requires documents to be produced in advance of the further examination, then any failure to produce those documents in advance can only be enforced under Part 81, not Part 71.2. Now, we actually reserve our position on whether or not that's right, but it doesn't matter for present purposes because the Elaine order required the documents to be produced on the date of the hearing.
And they're not produced anyway.
Exactly. I suppose just finally dealing with this sort of contempt condition point, what the judge was seeking to do here, in this case, was to ensure that in circumstances where there had been a campaign of delay, evasion, and so on, and lies, the further examination that took place was effective. And that further examination should take place on the basis that the original Allain order has been complied with. That is an order which is and remains, and always has been, binding on Mr. Windhorst. And one can immediately see that if the further examination would take place in which Mr. Windhorst did not comply with the terms of the Allain order requiring him to give the disclosure, there would be a risk that its effectiveness would be significantly fettered. And indeed, it would enable Mr. Windhorst to entirely undermine the purpose of that order and the court's authority by turning up to a hearing without having given the disclosure required. Now, there is nothing in any authority, and you have been shown no authority, that says a condition has to directly track the established contempts. Insofar as we can discern a principle from the authorities that it is the point of making a committal order is to secure compliance.
Like one of the points.
One of the points, well, indeed, and many others as well. Certainly one of them is to secure compliance. And the judge's discretion must be to do what is best, having decided to give mercy to the contemner to ensure compliance is achieved and that the suspension meets its object. And in order to meet its object, Mr. Windhorst has to give us the documents as well as turning up to the hearing. And in any event, it's actually accepted by my learned friend that that is sufficient. He says in his skeleton at paragraph 24, the conditions should be closely related to the original breach. He doesn't say they have to be the same. And of course, in this case, they are, because it's a consequence of the original breach, the non-attendance at court of the documents not handed over. And in my submission, really, all of this boils down to an attempt by Mr. Windhorst to pick and choose the conditions on which his sentence was suspended, which is not a course of action open to him. And logically, if his arguments were right that there is no power at all to impose conditions on his suspension, or that 4C doesn't work, then given the judge's findings that a fine would not be sufficient and that confiscation of assets would not be the right penalty, the only logical outcome would be to replace the suspended order with an order of immediate committal, which Mr. Windhorst could then purge by providing the relevant documents and agreeing to attend a further hearing. So that is actually where this argument goes anyway. Would your lordship excuse me if I just turn my back?
Yeah.
My lords, unless you have any further questions.
Thank you very much. Mr. West.
Thank you, my lords. Very few points in response from me. I think on that last point, the application that the respondent made was for a suspended sentence. It suggested an argument as a way of making the point that if this point were resolved in my favour, that might have led everyone down a different route, but that wasn't what was applied for here. I don't have any response to make on ground one. I think you have my points on that, and likewise on ground two. On ground three, all I would say is I recognise there are difficulties with the approach I'm urging on you because of Rule 75.8 not fitting naturally in the scheme. But in my submission, as you've heard, I say it's a principled extension, and that the law was developed in that way because, as my learned friend says, it is a self-contained procedure intended to deal with to be dealt with cases throughout the civil courts. It's a streamlined procedure, and it omits several steps to the point where you have a straightforward procedure, a straightforward order very quickly. I accept that it does give rise to positive conditions where there may not have been a breach of those conditions, but I say that's an exception from what I say the normal position is under the common law under Part 81. And I think, as my Lord Justice Newey proposed, if there were two orders, I think you would have to then establish which was the order. That was the original order under 71.8, and condition that would be the order on which the sentence was suspended. I don't think it's possible under 71.8 to bring in terms of other orders that are outside the Part 71 process. My Lords, unless there is anything further I can assist you with, those were all I had in reply.
Thank you very much. I think we'll just rise for a moment.
Court rise.
So we might be able to stay unless they're going to write it very quickly.
I suspect they might give it now.
They may do. Exactly. Yeah.
No, I'm trying to approach this without it.
No.
Because it's a condition.
Yeah.
I could affect. Condition 4. Agree with the jurisdiction. It's going to be some part. Also, I think that fuels the fire.
Yeah, let's see what they say when they come back. I think we need to know where we stand. Forget about Windhorst, I'm more concerned about us. Does it know what to do on his behalf?
Well, no.
I expect we'll get a pretty clear steer.
Well, I can ask. And see if we can deliver judgment on the point of that.
Well,
I wonder if that's something I can see if I can ask.
yes. Yeah. That's probably the best way. Yeah. Yes.
Rise is able.
So I am intrigued, and it's really a question for you, Mr. West. In the update to the supplemental bundle, under tab 11, we've looked at some of these documents in this tab because they related to the categorisation of documents that went to the, I think went with Mr. Hooker's letter of the 22nd of April. But it's an email before that at page 277. Do you have that?
Just turn these up, my lord,
Yeah.
to 6.77, yes.
It's relating to a different part of the order, but there's an email from Mr. Slade to Mr. Hooker that says, my client is obliged to cooperate to achieve a listing prior to 31st of July. He will do that and I will assist him. Could you just update us on where you are in terms of whether that listing has been agreed? Or
It
when
has
it's happening?
been agreed. I believe it's listed. I don't have the date to hand. I think it's in
6th of July. 6th of July.
yeah, the 6th of July.
6th of July. And that is for the examination.
That is for the examination, yes, my lord.
And that's obviously, one assumes, unaffected by the outcome of the appeal.
The examination is, my lord, yes. The requirement to produce documents would depend on the result of grounds 2 and 3. The fourth condition of suspension, that is the requirement to produce, I think, 28 days beforehand. 14 days beforehand.
Which, if my maths is right, by the 22nd of June.
Indeed, my lord, yes.
I can see all the solicitors behind both of you agreeing with my maths. So the outcome of the appeal, therefore, impacts whether the contempt law produces the documents actually on the 6th of July or by the 22nd of June. Is that right?
It does, my lord, depending on how you deal with the third ground of appeal, but yes, potentially.
Is that right?
I think if you were to conclude that the order was made under Part 81, but there was no jurisdiction to make it at all, that condition. But
There's still an order for him to produce the documents, is there?
there is still an order to produce the documents, an underlying order indeed.
One practical issue is, do you need the answer before the 22nd of June on this appeal? I mean, if we simply reserve judgment, you may get it before the 22nd of June, or you may not.
Well, I think my lord, Mr. Windhorst would like to know what it is that he will need to do by then. It may be that we can agree some sort of position that wouldn't prejudice the outcome of the appeal between ourselves. But it rather depends on the result as to the scope of what it is he has to do.
Well, he has to do it anyway. It's the date by which he
The
has to
date, indeed.
I think we might go out again for a moment.
Court lies if able.
Totally well dangerous. Where it was. Yes. Yes. It's just concerned.
Court lies if able.
Where we've got to, Westminster MacDonald, is that we will dismiss the appeal, but for reasons to be given in writing later. You will, in the normal way, receive the draft for you to correct our English and typing. That won't, of course, be an opportunity to re-argue anything. We'd be grateful if at that stage you would also seek to agree an order dealing with consequential matters. If there are points on which you can't agree, could we please have brief written submissions, and we would expect to settle the points in the order that we make. But for today, the parties should know that the appeal is dismissed.
Thank you, my lord.
Court lies if able.